Good afternoon to all. Welcome all in our today's innovation activity webinar. It is our first webinar in dealing with innovative activity. So, for today's webinar, we have an eminent speaker, Dr. Pranita Joshi Deshmukh, madam. Besides Ayurveda, she is an Ayurveda faculty, but beside Ayurveda, she has she has been working as research coordinator. She is working as an IPR woman scientist and many more. So, first of all, I welcome you, ma'am. Welcome, Pranita, madam. Now, a short detail about madam. Dr. Pranita Joshi, madam, she is an enthusiastic researcher, clinician, academician. She is basically a professor and HOD of Sharir Kriya department from Sumati Bai Shaha Ayurvedic Mahavidyalaya, Pune. Madam has more than 15 years of working experience. She is working as an editor, writer. Madam is working in quality system of healthcare of internal auditor, ISO standard, and Ayush assessor for NABH, and deputy coordinator for institutes NAC committee. Madam is recognized as an education technology and researcher for MUHS as a methodology faculty for basic and advanced training program. Madam is awarded by Women Scientist Fellowship of CSIR, that is Council for Scientific and Industrial Research. Madam is a trainer, yoga and basically therapeutic yoga trainer for pregnancy cares and joint rehabilitation. Madam is handling Satyaniveshwanam Today journal, which is quarterly journal. She is managing editor for that journal. Madam is a research coordinator of her institute. Madam is experienced corporate wellness trainer for multinational companies for delivering speeches and wellness awareness training program on Ayurveda. She is an most appreciated speaker of Ministry of Ayush e-educational portal, that is ayushguru.org. Uh, Madam is jointly implemented by Jamnagar Ayurveda for undertaking video-based teaching and learning for a global community, not in India, not in Maharashtra, but global community. Madam has worked for 3 major international documentaries with Dutch TV channels and various topics on Ayurveda, yoga, and meditation. Madam is awarded by International Paul Harris Fellowship and Service Above Self Vocational Excellence Award. So, such an eminent speaker we have got today for intellectual property rights and for how we can manage our IP management, basically intellectual properties. What is mean of intellectual properties, that we will get to know from Pranita madam. I welcome you, madam. Madam, over to you.
Thank you so much, Dr. Mrinal, and it was really kind of you to introduce on such a elaborate manner. But I would like to mention few things here. Please do not take all these things in mind. But I would like to mention that this is an introductory lecture where we are going to see various formats of intellectual property rights. Overall, this subject is new, and for us as Ayurveda practitioners, I hope everybody is from Ayurveda here. And
yes, ma'am. Yes, ma'am.
So, like we are now aware about various patenting possibilities in Ayurveda, not only in patents but trademarks, copyrights, and how we can actually encash that opportunity. And at the same time, I would also like to highlight as a startup, if somebody is thinking about certain process or certain manufacturing, pharmacies or certain units, there is a vast scope of IPR altogether into that. So we are going to see those formats, and maybe this lecture could be primitive for those who have applied for patent, or who are already having their own trademarks or copyrights. But keeping in view everybody's interest and putting it on the introductory format. So this whole journey started for me when I was trained as a women scientist for IPR in 2008-9 batch with TST CSIR laboratories, and with that I got some experience with TKDL and how to draft patent, how to search patentability overall for the innovation. So today's objectives are very clear, keeping in view the audience for today. And I would like to mention that what is the intellectual property? So we will be highlighting those aspects. Second, I would also like to mention promoting and protecting IPR in healthcare sector. See what happens. There are so many myths and misunderstandings about IPR. We are going to also identify why this promotion, why this IPR protection is required altogether. And I will also introduce you various formats like patent, copyright, trademark, or industry designs, and GIs or trade secrets. And to just elaborate all these aspects in terms of healthcare, how we can identify the strengths, weaknesses, and opportunities as well as threats. So that I'm going to also give that food for thought for everybody. So overall, if you go by the definition of intellectual property is directly referring to the creation of mind. That means invention, something which was not there before. And it could be from literary or artistic work or symbols or names or images, anything which can be or which is being used in commerce or which can be commercialized. Okay, so this becomes a property, intellectual property. But the overall idea of intellectual property is divided into two. First is industrial property, and we are aware about one aspect of industrial property, patents. So I'm also going to highlight other aspects of it, like trademarks, industry design, geographical indication. They come under industrial property. The second arm of intellectual property is copyright, covering literary works. So overall artistic things like music, films, or paintings, drawings, photographs, or even sculptures are protected under copyright and literary works. So that is the second arm of intellectual property. In today's lecture, we are going to see each one of them and how healthcare sector can actually get collaborated into that whole format. So when it comes to rights, the term rights, the whole approach changes because intellectual property is something which is related to innovation. But when intellectual property rights, we say, it means that it has certain commercialization kind of a scope, and intellectual property rights means that you have the full caliber to practice those rights, like just the way we bought our car or our house, and we have all the right to lease it out, to sell it, or to rent it. So that is how the owner gets the complete benefit of that product, of that property. Similarly, in intellectual property rights, it is like assignment of those property rights through patents, copyrights, and trademarks. So we can actually, those who are having those properties with them, they can exercise that monopoly of using that item for a specific period. Every IP has a specific period. So suppose I have a patent. So I will have 20 years of exclusive time to practice my property rights, or to exercise that monopoly that nobody else will use the same patenting idea for other commercialization aspects. So they need to take prior permission or approvals, or maybe they can ask for lease or something like that, where I can allow them to benefit from my invention. So it becomes like a property, and that not only allows to exercise the benefits, but it also allows to prevent others from using it or dealing it or maybe tampering with the product or idea. So anyone who is doing it without the permission of the owner of the property they can be legally sued and they can be stopped or asked for the compensation of damages. So this is something which is very unique in terms of overall intellectual property, because this has a vast commercialization caliber. So suppose a house will have a say X amount of uh, say commercial value, or a car has X amount of commercial value. But patent has something which is differently calculated, because one patent, like suppose we are talking about COVID vaccine. So if somebody develops a new COVID vaccine, that caliber of commercialization is calculated in a different way. So the overall commercial angle is high in IP rights, and that is why we need to know that aspect very well. So why we need to really promote or protect our intellectual property? And there are so many reasons for that. First and foremost is progress and well-being of the humanity based on the capacity to create. What does that mean? I mean, if we are working in technology, if we are working in healthcare sector, and suppose we are developing some new innovation, say something for diabetes care, and if we can reduce the insulin intake, or if we can reduce the complications further for the disease-oriented complications, we can definitely work for well-being of humanity. We can definitely work for the progress of the humanity. Or suppose I'm inventing something which is like a portable uh, water purifier, okay? And there are so many patterns for that. So portable water purifier, which has no power required, or we can use it everywhere. There is no need to change the filter. Something which is like unique, and those will definitely help in well-being of the humanity. And that is why new works are needed in our culture. New works are needed in our technology. Secondly, when we have our innovation, and if you think that okay, my innovation is not protected, and there is a chance of getting it stolen or something like that, then maybe the innovator will think that okay, there is no point in getting into that much of trouble. But this IPR gives you that courage, gives you that assurance that your innovation is protected, okay, and it encourages the commitment of additional resources. Like suppose I'm having a patent and I want to invest on manufacturing of that drug now, so I will have assurance that okay, my formulation is now patented. I have certain legal protection, so that now I can invest into manufacturing. Now I can invest in some other work related to my invention. Okay, so that legal protection really helps as an encouragement for the scientist or the innovator. The third important reason is when we have a good number of intellectual property with us as a country, overall economic growth, overall creation of jobs and resources for industry, for commercial gain increases multifold. For example, when Tata Motors launched Nano, it was like something which was unachievable dream of Tata's, and they were literally strolled from all across the sector that it is not possible to manufacture a car in say 1 lakh rupees. And it was that time it was a challenge they took, and they decided that it is a possibility that we can have a low cost utility vehicle for a small family, and that can be created. That innovation is possible. Tata Nano came into the market and they launched it on a larger scale. That car was protected with so many design patents, so many technological patents, that those patents really gave up the revenue. They developed the new economic growth. They created new jobs. They created new industries, because small car sector was newly introduced on a different platform. And overall, not only in terms of a social commitment, but overall in terms of enjoyment of life, quality of life was improved. So simple one innovation can trigger this cycle of changes, and that is why IP protection is very important. Now, suppose if Tata's would not have been protecting those kind of, the technological advancement of that car, anyone would have come and copied it up. They would have sold those cars into their country and got the benefit. But just because it was all protected, everyone in the sector needed Tata's approval, permission, because they were using that patent, using that innovation from the Tata Motors. So that is how it really helps in not only the economic growth of that particular inventor or his or her company, but overall national R&D also gets developed. Because as a country, if we have more patents, if we have more protected intellectual property, automatically there is a potential for economic development, for social cultural well-being, and other countries will look up to you. Like in case of vaccines also, now everybody is looking up to Indian companies for a provision of vaccines across the globe. And ultimately, who is the benefiter of this? The beneficiary is a layman, a community, because any new innovation, now imagine that era when people used to travel like hours together or days together in say ships or boats or that kind of utility vehicles where the distance between 2 points was so much and it was so troublesome that the travel was so difficult. So overall expenses of goods transfer, overall expenses of people's communication was high. Over the period of time, there was a good development in terms of IP for overall aviation industry, the speed of the cars, the speed of the trains, or even for that matter, commercial ships or cargoes. So now, ultimately, the community is getting the benefit. Now the globe is coming together. There is no matter of distance anymore. Each and every person has a full freedom to across the half of the globe in a matter of fact, and they can work from so many areas. Even this format of virtual meeting, this is an development of some innovation. One innovation is making us capable now to deliver the lecture in Gujarat from Pune. So that is how the community is also getting benefit by protecting and promoting the IP. So it helps in striking the balance between the interest of the community as well as the commercial gain. So maybe the Zoom might get the benefit, or some other format of these meetings will get the benefit, but community is also getting their share of benefits, and that is how the invention can flourish or they can be developed and protected. The most important thing is we see these intellectual properties across all the sectors around us, but we lack in healthcare somehow, and it is now getting utilized in other sectors, but somehow we are not that much ready to explore. See, even a bottle of Coca-Cola has so many patents and so many aspects of formats of IPR being used, like patenting of the seal, that cap, or the trademark dress of that bottle, the color, the format, the logo style. We can identify that it is a so and so company's bottle. And even the formula of that cold drink is a trade secret. Nobody else can manufacture the same formula. Or the overall appearance or the design of that bottle, the copyrights of that logo, and everything is getting covered. And not only in this beverage industry, the brands are being created in say various films, or in even the fashion industry, art, literary areas. These aspects are now being taken very seriously because these are the innovations and they relate to the brand well. So a person, a layman, can actually identify quality with that brand. That okay, I will not choose any ordinary thing. I will just go with this particular dress, with this particular trade secret, with this particular trademark or copyright or patenting product, because I know that this will also qualify for the desired quality I am seeking. So, and that is how it becomes reliable. And that's why people are now preferring over quality than the quantity, and it becomes people's choice. Automatically the commercial gain improves for the company. Even in case of mobiles, we see that there are so many aspects of patent formats. Trademarks are there used for various tunes or tones. Designs are used for the format of the screen, arrangements of the buttons, or trade secrets. Like the moment you get to know that iPhone is getting launched, everybody is interested to know what kind of technical things are getting added up. or copyrights, the softwares, the manuals, or even the patents or utility model, the whole operating system. Everything is fully patented or fully protected with various formats of intellectual property, and that gives them the reliability. Everybody chooses that kind of a product, which is coming from the innovation think tank. So, like we have just seen this chart, that intellectual property has basic two divisions. First is industrial property, and second is copyright and related rights. When you think about industrial property, it is again getting divided into patents, trade secret, industrial design, trademarks, geographical indication, plant varieties, and farmers' rights. And second is copyright and related rights. So, if you go with the next branch of the in the intellectual property, we can see the copyright. Now you must have seen this C, capital C and the circle around it, or the capital R and the circle, or CC or PM marks around you. Even if you have right now your phone in hand, you can see the name of the phone has certain trademarks or copyrighted symbols. So, in case of anything which is original, literary, dramatic, musical, or artistic work, that is having a capacity to get protected under copyright. Basically, copyright is something which is a legal term which is used to describe anything which is coming from the creators and they are having certain literary or artistic value. And they range from various aspects like books, music, paintings, sculptures, even films, or music tones, computer programs, databases, or even advertisements. Amul advertisements you must have seen, you can relate to that brand. At the moment you saw that particular drawing, or common man drawings, you can relate that this is the author of that particular drawing or cartoons. So that is how they give you identification for the creator. And that's why copyrighted works include literary works, artistic work, musical, or recordings even. Suppose I want to record this lecture, this becomes my copyright automatically because it is getting recorded, and we are getting a disclaimer that okay, this is getting recorded. So I agree to that recording, and that is how it becomes a copyrighted item. Even there are so many industries which are using copyrights to a large extent. Like I mentioned about film industry, they are having many copyrights protecting their soundtracks, their songs, sequences, or even the screen cinematography or the screenplay, the script. Everything is protected. Suppose somebody asks that okay, this particular script is getting copied from the original, then they can give evidences that this was the first script and this is getting copied or something like that. So they can actually fight for that originality, and this grants authors or creators a right to protect their work. And this is something which is very unique. And now, like I mentioned, we are now into a small world. There are high chances of copying it up from the maybe, and it's initially in initial days people used to call it as inspiration, but now it is not like that. Anybody can take action on that particular infringement. So even the performance, stand-up comedians or TV programs or actors, music programs, music shows, or broadcasting organizations, they are taking copyrights to protect that particular part of the sequence of their work. So how this can be, covered into healthcare sector? So you must have seen that there are so many aspects of healthcare. That suppose I'm writing a book, okay, and that book is very illustrative. I'm drawing some drawings there, or I'm explaining certain aspects with that drawing. So automatically that is something which is being created for just to explain the things in that book. So automatically it becomes my copyright, and I can get it registered also. Certain databases, certain, like we are aware about databases in Ayurveda research also, they're all copyrighted items. Or computer programs, suppose you are interested in developing certain new applications for mobile, or certain computer programs to assess somebody's prakriti, or say Agni Pariksha. So that kind of computer program or IT related thing can be actually copyrighted. Or if somebody is from Dravaguna and they want to draw something related to the plant, and they want to draw each and every part of that plant, maybe in cross-sectional views and various aspect of that particular design of that plant, they can actually have that painting copyrighted. Okay, so even if you sometimes think that उसमें क्या protect करने जैसा है, but there are so many opportunities in healthcare where we can have our copyright thing registered. Now, what will be the benefit of it? See, the benefit sometimes did not necessarily come into a commercialization format, but sometimes the acknowledgement of ownership, acknowledgement of creation is also very important. That this particular painting is drawn by so and so the Raviguna expert, or a certain collection of paintings is now converted into a book, or it can be used as a reference book for the Raviguna experts. Automatically, that authorship, that ownership is very important in propagating our science, and that's why it is very important to have it registered, get it properly registered or documented. And then even for the matter of panchakarma, there are certain technical drawings for equipments or certain design drawings. Those drawings can also be protected. The overall instrument can also be protected later on, but the drawing itself can be protected. And so there is a vast scope of copyrights around you. We just need to identify those aspects. The second thing I want to now come into industrial properties with the industry design first of that industrial property. And it is a type of intellectual property which protects the visual design, like aesthetic of the product. Suppose I'm having a design of, say, a Panchakarma equipment. I can actually have an industrial design thing registered for that. Like suppose, and because now this is a very recent addition into IP by Indian law, the Design Act of 2000, and this protection gives exclusive right to make, sell, and use articles that embody the protected design, like we saw for the Coca-Cola bottle. Similarly, if we are designing certain products, maybe aesthetically, even the color combination or the formats, the various aspect of that particular parts of that machine, that can be protected. And it consists of shapes, configuration, even the composition of the matter. Like suppose you are making something from wood or something from stone, that also can be protected. The overall pattern, combinations may be three-dimensional nature. It must be three-dimensional. That is what we want to highlight. But it is not that two-dimensional cannot be protected. It can be done in terms of drawings or overall. But the only point is if that drawing can be converted into a product. Like if you are having a technical drawing about it, that can have a potential of converting into the product. So overall industrial designs are very important. I wanted to tell about copyright, that the duration I just missed on that. Copyright has the highest duration of protection. Like suppose as an author of, say, one novel, uh, he is alive right now, and suppose he dies in 2025. Okay, so if that book was published in, say, 2000, so those 25 years plus after the death of the author 60 years, so automatically the duration of the protection is highest in copyright. So after the death of the creator, 60 years are added. In this kind of a format, industrial design, the duration of the protection again varies country to country, but in India it is 10 years and it can be extended for 5 more years. The third aspect of industrial property is trademark. And again, with these products like Himalayas or Organic India or Dabur or many more, you must have seen this registered or mark or TM mark. Now, trademark identifies certain goods or services which are produced by an individual or the company. So maybe a logo of the company, or suppose you are an individual and you have your own setup of clinic, that logo of the clinic, or maybe your letterheads, all these kind of services or goods can be identified or linked to the creator. Okay, so that, and even if you are aware, many of the, even our ancient scripts, the poems or the books, they have the mention of the author who has created this stanza, who is the creator of this mantra. You know, that is how at the end line they used to mention. And similarly, in many of the paintings, they used to put their mark of identification. It was their style of identifying that work, their style of signature, and giving identity to that work so that it automatically gets connected to the painter or creator of that particular artwork. Similarly, in nowadays, we are now evolved system for trademark registration and protection. So this system helps us to identify and purchase a product or even service based. Like suppose I see a capital M, I can immediately think about McDonald's. Okay, if I say a capital N in red color font, I can immediately connect it to Netflix. So automatically, these are getting, getting that consumer attention, so that they can relate those products to the individual or company. Okay. Similarly, suppose, and it is not necessarily that it should be like matching. Apple logo, it's an Apple, but it is related to the computers. Okay, so it is not necessary that it is connected, but that logo, that mark can identify a product, and then a consumer can decide whether they want to purchase it or not, because they will relate to the quality, they relate to the branding of it. So any letter, number, word, even the graphics or the smell. Many of the Switzerland companies are using their perfume smells for trademarks. They are protecting those particular aromas because they don't want their perfume industry to suffer just because somebody is stealing their product. Or a combination of colors that can be covered as a trademark. You must be listening to the Doordarshan news, and that sound which comes at the beginning, that is also protected as sound mark. So many opportunities are there in trademarks aspect also. So suppose where you can actually use it. Like I mentioned, there should be identity to your product. If you are developing new products, say cosmetic products, or something which is related to medicinal products. You have your own GMP company, if you have your own pharma company or a manufacturing setup, please get these products registered so that nobody will prepare the similar products in the market, and your identity, your quality, your the consumer connect will be mentioned. So not only in terms of the product, but overall, if you are even practicing, and if your clinic name that can be protected, that clinic name can be trademarked. So, like just in case of, you must have heard so many franchisees of various clinic chains, and those are using the same trade dress, the trademarks, logos, the color combination of the whole system, the interiors. So that is how people can connect the franchisee unit to the main chain of hospitals or maybe clinics. Okay, so trademarks are really effective to connect to the consumers on a large scale. So how to do that? How to register trademark in India? It's a very simple process, and the whole registration process is hardly 15-18 months. And once it is approved, you will have 10 years of approval time. At the end of trademark, you can that tenure you can renew that also. But sometimes there could be a design change or something. You can go for a new trademark application altogether. So step one is identify your brand. What exactly you want to think, you want to portray. That what is the unique or reliable thing which your company, your services refer to. Accordingly, you design your trademark, maybe with the help of designer, or you yourself can also design that. Go for the trademark application, fill it up, give the particular application cost is very less, and it's a one-time fee. And form TM1 is the requisite form. You fill in the details, and step fee is once these application processes are over, you will get the acknowledgement. If you are doing it in e-filing system, it is instant acknowledgement, and that is how you submit it to the trademark office. Once it is submitted, the registrar, the trademark registrar, checks that this brand doesn't exist in the market. It is totally new. The overall design is new, and They will, after the examination, they will publish that, okay, we have received so and so application for so and so name or the brand. And if that release, that publication is for layman, everybody can read that trademark. We are going to see that. So what happens if I think that this trademark application is directly related to my product, I can raise an opposition and I can inform patent office or trademark office that this is already in public domain and this trademark may not be registered. So automatically you'll have a query and automatically the whole process will start. But if there is no opposition, nobody is making any claim, so within the stipulated period of 90 days, the registrar accepts the application and then you are allowed to use the trademark symbol next to your brand name. So automatically you'll also get the certificate of registration. And that gives you an additional edge to the credibility of your work or services. The next industrial property is geographical indication. Directly, we are not related to this IP format, but indirectly, we are definitely related. Like the geographical indication gives identity to the origin of the goods or services. Like suppose Mysore sandal soap or Alfonso and mangoes from Ratnagiri or Kolhapuri chappals or Puneri pagdi. They are giving a direct linkage to the specific geographical origin and the processes, the reputation of that place to the product. Okay, so this particular right gives the identification to the geographical area so that nobody else can manufacture the same product outside of that geographical area. Like nobody can manufacture Kolhapuri chappal in Pune because that is protected. And what does this protection do to the to the creators? They will have their own monopoly of exercising of those rights. Every that particular art will be flourished in that area. Artists will not, leave that particular art. They will have assurance that this art is having a good commercial value. So local grown market will be developed, local goods will be cherished across the globe, and they will also bring up the new commercial avenues. So food products, fruits, fabrics like Kanjivaram or even the Paithani, they are all protected because those weavers needs that kind of assurance that okay, our fabric, our kind of art is not getting into that technological trend. Nobody is just printing it up. Nobody is just relating the importance of artists. So these geographical indications gives them added advantage, and automatically the products gets that desired quality. So and it is applicable for 10 years of protection. It can be renewed. Many of the fabrics, food items are getting registered nowadays. The next is plant varieties and farmers' right, which is again a new addition into IP format, and it was in 2001 under PPV FR Act, and it was enacted a grant of IPR to plant breeders or researchers or farmers who are developing new or extant plant varieties, and they will have the full right to exercise right to produce, sell, market, commercialize, import it, export it, or distribute that variety across the globe. So that particular advantage is given to the farmers, researchers here, and plant breeders, researchers are also covered under this IP format. The protection is varied according to the field crop or the varieties, but it is approximately starting from 15 to 18 years. And this basically this right is a dual right because it gives protection to the variety as well as the breeder. So no one can replicate the same variety, and no one can claim that this variety is theirs. So both are getting advantage. Okay, the breeder also and the plant variety also. And this was very important for not only farmers but also the researchers, and that is how Ayurveda is closely related to this particular format of IP, because sometimes we tend to use certain formulations, certain herbs which are under the protection of this right. So you need to have a proper approvals in place to use it for your product or to use it for your research. And generally, to know more about that, this has a whole like a separate section of the lecture. But I just tell you that in terms of Ayurveda practice, we have to see if you are working into that research mode, if you are also cultivating some new plant varieties or plant breeding practices you are having at your end, please make sure that it is and if it is not somebody else's. And secondly, if it is original, it is genuinely a new breed of the plant, go for this protection. This is going to help you in long run. And with the recent developments with ministry, so many funding opportunities are there for developing these research avenues into this field. Now, there is one more thing which is coming under industrial rights, trade secrets. And trade secrets are that format of IP which comprises of maybe formulas or practice or processes or maybe designs or instruments which cannot which are not actually known to anybody else other than the owners. Why this is so? Because they think that only 20 years of protection is not enough. I want to protect it forever. But that kind of a machinery, that kind of setup is really very strong, to safeguard one formula of Coca-Cola or to safeguard one recipe of KFC. A whole lot of energy, manpower, resources are utilized. Maybe if you have that kind of a innovation which can be used for more than 20 years and you think that it is a trade secret and you don't want to share it, you can do that. Provided in India right now, there are not direct laws to cover it, but in indirect way, we can cover that up. In other countries, there are separate laws to protect trade secrets. Now, how healthcare sector can get benefit out of these IPR formats? Basically, the current you can say the whole current healthcare field is getting into a transition mode, and most of the changes are happening in this decade because technology is at its peak. We as Indians are exploring in various research avenues. We as Indians are having many backups of funds and many research institutes in place. So these recent technological advances along with personalized medicine, along with say markers or dedicated like a customized kind of medicinal avenues and more. And people are working towards many new diseases with some formulations which are economic, which are easy to use and can be commercialized on a large scale. So there are so many possibilities of patenting in healthcare sector. Similarly, genetic engineering is a new field which is coming up, big data, healthcare adjacent technologies. Like I can use many instruments to screen the patient, to diagnose the patient. At the same time, I can use instruments and IT to treat the patient. I can actually see what is happening in the cell. I can actually see what is changed in the genetic setup. So many developments are coming up, and in healthcare sector, we need to now rely on newer innovations coming up in the market, and we need to be buckled up for this kind of demand from the market. Now people are asking for personalized medicines with lesser side effects and greater efficacy. So we need to work on these sections of the society. I will also mention now the most important aspect of patents. So it's an intellectual asset, and you all must have heard about patents. And it's a exclusive right granted for an innovation. Generally, patent provides the patent owner with the right to decide how and whether the innovation can be used by others. So, but in exchange to this exclusivity, that creator, that inventor needs to share all the details to the patent office. So, patent office then published this document for society. Anybody can read it. So, if somebody thinks that this patent application is already been used, it is already in public domain, they can again raise the question similarly like a trademark application. But in this case, it is more, you can say, in-depth analysis of each and every claim you are making. The exclusivity of the patent is 20 years, and it can be again extended depending on various formats of it. That can be built in some other lecture, but that is called as evergreening of patent. And patent also gives, exclusive privilege of making, selling, and using the invention. So there is a vast commercial angle involved into this in comparison with the other formats. So many of the researchers are nowadays are following up into patent cycle. So it starts with idea or a product or a process, and you need to think that okay, whether it is a novel process or idea, whether it has inventive step, something which was not done before, it is not obvious for the expert in the domain. Like suppose I am Ayurveda physician and I am having my Ayurveda practice. So I'm just mixing 2 or 3 drugs together and I cannot apply for patent, because that is just obvious. Anybody which is expert in the field can mix and match various herbs and they can utilize for certain diseases. So that is not called as inventive step. Inventive step is something which is non-obvious for the expert in the field. Along with that, we need industrial applicability. Like suppose I'm working on some innovation which cannot be replicated on large scale, which cannot serve the purpose of society needs, then definitely the industrial applicability becomes very less, and to really spend your time, energy, and money on that kind of innovation is really not required. So basically, all 3 factors, novelty, inventive step, and industry applicability, are considered together. And once you think that, okay, now this is patentable, and that is why we call it as patentability search, that, okay, really this is a patentable application or not. And once if we are convinced that, okay, now it can be processed further, we go and search other databases with patents, and then we can search that, okay, similar idea is not in the market, no one else is doing it, this is completely unique and it is innovated kind of a product. Then you will submit your application with full disclosure, we call it as claims. And suppose your application is on 1st of January 2021, so that becomes your priority date. The 20 years are calculated from 1st of January 2021. Okay, so once that application is submitted, like I mentioned, maybe within a period of 18 months, it gets published, and then it goes into, if nobody has any objection on it, it goes into examination stage. Examiners, the patent examiners, they review your application thoroughly. They have their own set of databases and they review it. In Ayurvedic kind of a scenario, we have a separate TKDL, you must have heard, traditional knowledge digital library. So that database is only available with patent offices, and they go through that also, that whether your application is similar to the traditional practices. So you cannot go for something which is already done by our granthas or compendias. Okay. Then if everything is smooth, and then there will be a first examination report, FER, and it refers to if there are certain queries by the examiner, they will ask for that. If there are certain objections, applicants are asked for hearing, and the response to FER has been filed. And then if there are no pending objections, it goes for the next stage of granting of the patent, and then you will have to pay the fees every year. Okay, that is how a simple cycle takes place, but the duration is sometimes very lengthy. Sometimes it may take years together. There are various types of patents, like utility patents are something which are for new product, process, or machine, or something which is related to the manufacturing or composition of matter. And but these are not covering the plant or agricultural use creations or botanical creations. Design patents are totally related to the ornamental design or prosthetic value of that article, and it only deals with the protection of appearance of the article, not the article itself, just the design of it. So inventor, like I mentioned about the design patent for certain equipment or certain machines, I can go for design patent along with a utility patent because I can manufacture that machine multi-folds, I can sell it up, so I can have dual kind of a benefit. Plant patents are different again. Any new variety of plant which is asexually reproduced can be granted a plant patent, but it should not be previously existed in nature or in uncultivated state. So certain new plants or mutants, hybrids or seedlings are getting protected, but that has their own limitation of it. I have mentioned about TKDL. This is a digital library which is accessible to only patent office. Then there are separate guidelines for processing of patent applications which are related to traditional knowledge and biological material. So please go through these guidelines. It's a very small booklet and which deals about if you are thinking about patenting your herbal formulation, please visit this guideline, and there are so many aspects which are getting clear. Because of time constraint, I'm not going into all these details. And here are some of the illustrations from CCR's website, and they have, you know, uh, worked on so many patent applications. Some of them are in process. So even the apex bodies of research are thinking about patenting their ideas, and this is something which is very important. Now, just to clarify the differences, I am just putting this table for the quick uh, comparison. So patents, industry designs, and copyright. Sometimes you might get confused, but in patents, it is a technical enhancement, which is novel, unique, and useful. In industrial design, it is only about the design aspect of the article. In copyright, it is more of an artistic or literary purview of that particular uh, creation. The duration wise also, copyright has the maximum duration. Industrial design is 10 years and which can be renewable for 5 years, and again for 20 years for patents. Maintenance can be done for patents with the annual fee for the 20 years of duration. Industrial design, there is a renewal fee, and in copyrights there is no fee required. However, if there are copyrights, some people also go for registration of the copyrights, just to have a safer side. And patents, if when to apply for patents, it needs to be before launching of the product into the market, or for our sake, before publishing our results, you need to think about patentability. In industrial design, it is again before launching of the design into the market, and copyrights, it can be done anytime. Then I'll just go through these quick links for you at the end of the lecture. I'm just taking you to the SWOT analysis. So here you can see the strengths of IPR. First and foremost is international recognition. If you are having an international patent in hand, that recognition is something which is giving you an additional edge to market your drug or innovation. Protection of Indian IP also gives you credibility. There are vast avenues in commercial mode, and now in India we have structured policies and laws in place which will protect and ensure for long-term protection of that patent or even other formats of IPR. However, there are so many weaknesses and threats, but definitely these weaknesses and threats are related to our lack of technical support or resources. The most important is lengthy timeline. Patenting takes a lot of effort, and not only in terms of the innovation part, but also in terms of putting that on the paper and submitting it to the patent application, because writing of the claims, designing of that whole application takes a lot of effort. And also sometimes we are not having that legal or technical support, so maybe we can struggle a lot there. Overall cost of patenting is high for an individual, and also there are limitations for traditional knowledge and also the risk, because like we have seen turmeric patent or basmati patents and how we revoked them. It was a long battle. So we also need to protect our science from the global threat. That is also a major threat there. However, there are opportunities like many foreign companies are looking into something which is naturally resourced medicines or with lesser side effects. So they are looking for more investments in Indian market. There is huge R&D support for something which is patentable, something which can generate revenues. Many research organizations, governments are helping out and they are providing R&D support. Also, now with the onset of COVID, we are all aware that there is a huge potential in Ayush sector and they can really contribute a lot in terms of public health, in terms of viral diseases or new diseases coming up, or overall improvement of well-being of the community. So there are so many opportunities where we can really contribute and get our IP secure. So I just would like to mention one thing here. Please, if you have something which is patentable, do not publish it immediately. Think about it, how we can patent it, how we can use different formats of IP. Then maybe you can go for publication. Because once it is published, it is going out of your hand. It is in public domain. Even if it is your article, even if it is your formulation, it is there in public domain and we cannot patent it afterwards. So I'll just take you to two websites here. Yeah, can you see this website? I hope it is visible to you all. So this is IP India website, and here you can see all the aspects of patents. This is the publication I was talking about. Then there is a design application, trademark, GI, and other information, training courses, or even there are journals, annual reports. This is a self-explanatory website, and here you can also see grievances. There are again, see here, publications. And they also have report of technical expert on various patenting laws or drugs related or scientific advisor or journals. They have their own journal. Then there are again forms available for designs, forms available for trademarks, GI. So this is a self-explanatory website. You can just go through this, scroll it up, and we can see so many external linkages here also. World Intellectual Property Organization, Indian Patent Office, or SIPP or IPAB. You can just go through these if you just click on that. I will again want to go to this trademark registry. I hope it is visible to you. Yeah, it is visible to you all. So this is Dr. Mrinal. Is it
Yes,
visible?
yes, ma'am. Yes, it is visible.
So this is a trademark registry, and here you can see application status, e-register, and these websites are really helpful. Even if you are a new in this field and you want all these formats, just to have more information, or you want to apply yourself, there are so many assistance and so many opportunities of trainings also. So here you can also see the events, like there is an online training, again there is a mobile app. If you want to see your application status, there is a separate grievance cell, and here I'll just go through this WIPO website. So this is World Intellectual Property Organization. It is in Geneva, Switzerland, and it's like a global organization which governs IP across the world. Here also you can see various IP services. They can also have their policies. They have recently developed a whole set of policy for traditional medicine. Resources, you can again see various IP databases. These databases may have certain access limitation, but at least you can scroll them up. They also provide technical resources for international classifications, because if we are going with the invention application, we need certain terminology, we need certain classifications. So that is how they provide that if you are seeking for international patent application. And also there are certain publications, country profiles. If you are thinking that your formulation is applicable in South Africa, like suppose our organization has a particular innovation in sickle cell anemia, and we believe that our product has a huge commercial aspect in South Africa or even in other countries which are African countries, and they have similar disease profile. So otherwise also you can see the country profiles and how those countries can be utilized for your patent application. Yeah, so this you can anytime visit. Okay. Yeah, so that is all from my side. If you have any queries, please ask. There is my email address and mobile. If you have any queries, you can ask. Over to you, Dr. Mrunal. Thank you so much for calling me for this wonderful lecture.
Thank you, ma'am, for this wonderful and brief lecture. Madam, I want to ask one question. While going for copyright, if an author is has his own book ready with him, but he had used some pictures or some demographics from internet or some from other source, then what would it be a copy? He can go for copyright, or what he can do?
Just like in our publications, we need to use references. We need to acknowledge
Okay. Huh.
the source of my information.
Mm-hmm.
It is advisable to use your own designs, even if they are illustrations. It is always advisable to your own designer in hand who can draw it up. You can illustrate your kind of images in the book. If you think that existing images, existing illustrations are useful for you, you can use that, provided the source. And generally for academic purpose, the copyrights are not considered as infringed kind of a thing, but you still have to take the permission from the creator.
Okay.
And simple example, I'll just show you here. There is a separate website for Creative Commons. So if you just go into, I have mentioned that on my slide of the copyright.
Yes.
CC in bracket, in the circle, sorry. So this is Creative Commons. So what happens if you are finding something on this website? Search for CC images. Okay. So suppose I am looking for content on Ayurveda. Now I am searching on it. Okay, I hope this is visible to everyone.
Yes, yes, ma'am, visible.
So these many images are available for me to be used, 830 images. Okay.
Okay.
In each and every image, I can see if this is relevant to my book or not, if it can be used. And if you think that they can be actually immediately copy pasted into your book, you can do that. But just mention that this has been procured for creating a shared. So here you can see license or public domain.
Yes.
So here you can see the aspects of image. Suppose I'm clicking on, say, this image. Okay, here you can see credit the creator. They have mentioned that if you are using this image particularly, you need to give the credit to the creator. The creator name Hari Prasad Malik is visible here. Okay. Then also share adaptations under the same terms. Suppose you think that this image needs certain changes and you do that, please share that to the creator again, back to the creator. So Each and every image has its own set of licensing guideline, and you have to see that, okay, on this domain, on this CC search. Otherwise, if you're using it from other angles, otherwise, if you're using directly from Google and you're putting it on your clinic book or something like that, there will be a high risk of or chances of infringement, because many of the brands are very serious about their trademarks, their copyrights. We cannot do that. Even if
Okay.
then first we have to take permissions.
Okay. So thank you, madam. Thank you for your brief information. Actually, we have decided to start off with innovative activities, and in that we want to know about IP and IP management. So in such a short notice, you have given us a time for this lecture. I basically thank you, madam, for your time and for your lecture. It was very nice lecture, madam.
Thank you so much.
Lastly, I would like to thank our CEO, Mr. Siddharth Mehta, sir, for giving us opportunity to arrange this. Our principal, Madam Vedmita Mashru, Madam, our vice principal, Vijay Telang, sir, and our clinical registrar, Dr. Mehul Joshi, sir, for arranging this seminar and giving us time to arrange this all. So thank you, madam. We would also, I would like to add something that in near future, if we want something brief on intellectual property, so we will contact you, madam. We want you to have such type of webinars again and again in near future. So,
Pleasure.
okay. Thank you, madam. Thank you. Thank you so much.